This is Rich Sierra. I'm the president of the Florida Small Business Legal Center. Welcome to Business SOS. I'm your host today. This is episode number 35 of Business SOS. Been doing this now for over 6 months. We're very excited that we continue providing you great content to help business owners navigate the legal waters of managing your own business. Before we start, I want you to participate in the show. If you have any legal questions you'd like me to address in the show, any type of issues that you may have or questions that you may have, please send me an email at rich@richsierra.com. Again, it's rich@richsierra.com. Send me an email with your legal question, and I will not mention your name. I'll address it in general terms, and at least to be able to give you some answer or clarification that you might have regarding any legal issues you might have in your business. If I select your question, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Today, we're going to talk about subpoenas. The title of the topic today is, I received a subpoena, what should I do? Okay, let's talk first, what is a subpoena? Subpoena is a writ, there is a court order for you to compel you to either testify at a hearing, testify at a deposition, testify about produce documents. When it's produce documents, it is what is called subpoena duces tecum. In Florida, an attorney can issue a subpoena. You don't need a court order to do that, but it is treated as if it's a court document. It is in order to compel you to produce documents or testify. Most of the time it's served to you through personal service, as it is done as if it's any type of court document to a process server, and in some cases can be done by mail. We're not going to go here a topic of process service because it's a whole different conversation. The bottom line is this. If you're a business owner, you received a subpoena for anything that says that you're compelled to testify, gives you a date, time, and place that you're supposed to show up. Okay, that is a subpoena. You're supposed to comply with it. Now, when you receive it, why would you receive something like that? There are a number of scenarios. For example, say one of your former employees, they used to work for you, got into a car accident, and then they want to, the attorneys want to get a copy of the employment records. That's just one example. Perhaps you witnessed something that, you witnessed somebody slip and fall. They might, have a subpoena for you to testify. There might be documents that you have regarding a business partner that left the company, but the documents are relevant to that particular lawsuit. That's a subpoena as well. Say that there is a divorce proceeding, and then one of your employees used to work for your company, was involved in that. So they might want to have the payment records or the payroll records of that employee to find out the earnings. So there are just thousands of combinations of reasons why someone might receive a subpoena. So if you receive a subpoena, the first thing you need to do is basically, again, don't panic. Nobody likes to receive court documents of any kind. And so if you receive one, just go ahead and understand what it is. It's a request for information that apparently you may have that might be helpful to whether it's the plaintiff counsel or defense counsel in preparation of their case. So that's really what it means. Do you have to comply with that subpoena? The answer is yes. However, there's some caveats to that. There's some exceptions, and we're going to go over that in a few minutes. But for the most part, you have to comply with a subpoena. My recommendation when you receive one of these is first, do not panic. It is a routine document, at least for us, to request those documents from potential witnesses or companies that might have information about our case. But do not go ahead and immediately start sending documents. Do not start doing that. The first thing you need to do, they usually give you some time. Sometimes they give you 20 days, 30 days, depending when you actually receive the request. My first recommendation is to talk to your attorney. just go ahead and send that subpoena to your attorney. If you don't have one, find one that understands the issue. And if it's a business context, you obviously want a business lawyer to help you. And say, listen, I received this subpoena. What should I do? The attorney will review the information, will determine whether or not it's a subpoena for you to testify at trial or testify at a deposition, or whether they're requesting documents from you that may be relevant to that particular case. So the attorney, let's talk first about ducis tecum. So ducis tecum usually tells you produce the documents, and usually has an exhibit. It gives you a list of the documents that you're required to produce. So you go with your attorney, review what documents they're requesting. A, do you have them or not? If they're business records, for the most part, you have them. Number two, are they confidential records, or they're records that you can provide without breaking any type of confidentiality agreement or any type of personal sensitive information that you might be sharing? Your attorney will be able to ascertain and determine whether documents should be produced or should not. So you go over those documents with the attorney, and there are two scenarios here. The attorney says, okay, these particular documents, yes, you can produce these documents. We will have file an objection. For example, some personal records are confidential. If they're, say, for example, looking for payroll records, but they're asking for the entire personnel file of the employee, there might be disciplinary matters in that employee's file. There might be some doctor's notes in that employee file. There might be some confidential information there that really is outside of the scope of what they're trying to obtain. So what would happen in this case is the attorney will call. If I'm representing this particular client, I will basically call the attorney and say, what do you need these documents for? And can we narrow the scope of what you're asking for? If they say, okay, we just want to know, how much this particular employee earned last year or the last 2 years, then okay, we can produce the payroll records. What else do you need for the entire file? We need, they don't need to know more than the information they actually need. So we kind of negotiate and begin to say, okay, if this is what you need, yeah, we can provide it, provided that we ask a non-disclosure agreement or a confidentiality order with the court to make sure that information doesn't go anywhere else outside of the scope of this litigation. So there are ways that we can negotiate providing information and narrowing the scope. So if we come up with an agreement, then we'll exchange some letters, which is fine. That is that the scope of the subpoena has been narrowed, and we agree to produce the following documents, A, B, C, and D. And we don't need a court order for that. I think with a letter from an attorney is sufficient for the purposes of complying with the subpoena. And at that point, then I will instruct the client, okay, get these records that we agreed upon. We're going to have a confidentiality order, a confidentiality agreement between the attorney and us. And then we'll just produce them by a certain date, via PDF, and then you don't have to show up anywhere else. You don't have to physically go to the attorney's office to produce documents. Those days are gone. We can actually produce documents now electronically, and you also need to have what is called an affidavit of business records, basically stating that you, as the custodian of records, these records were kept in the ordinary course of business, and they are basically true and correct copies of the original documents that were prepared at the time when the documents were created. You put that affidavit together, we send it out, you comply with the subpoena. So that is one scenario that we comply. We produce the documents that we agreed upon, and we comply with the subpoena. Now, second scenario, we disagree. The attorney says, no, I want everything. I want the entire file, and I don't care what it contains. We want everything. At that point, if the attorney and I do not agree on what documents will be produced, then we'll go to the court. I'll file what is called a motion for protective order and outline the grounds why the protective order should be in place. Might be confidential records, might be sensitive information, might be relevant information to the particular case. And again, we're not even a party to the litigation, but we have an obligation to protect the information of this particular employee. And then we go ahead, we set up a hearing, and the court will rule whether they agree with our position or disagree, or the court will basically narrow down the scope of that subpoena, that discovery, and then we'll enter an order instructing us as the witness what documents to produce and under what conditions. So that will be kind of the process in this case. What I will recommend here is do not ignore the subpoena. What happens if there's a scenario that you receive the subpoena, but the date, and it happens, sometimes people cannot be found. If it's done, in some cases, you can actually send a subpoena by mail through corporations, through companies, and just this in a private mailbox that people pick up their mail once a month. So what happens, you receive a subpoena, but the date passed. Okay, you say, oh my God, this should have been sent last week. I just got it. What should I do? No, again, do not panic. It happens all the time. That's happened to me that I send subpoenas and people just don't pick up their mail. We cannot find them. By the time that we find them, there's like a day for them to produce the documents. And I already know that's not going to be sufficient time. When I was planning 30 days to give them time to produce the documents. It's like that, you can call the attorney and say, listen, I just got this. Okay, I'm going to seek counsel to advise me on this, but can I get an extension of 30 days? And the attorney, for the most part, will say, you just received it. We'll give you some time to respond to the subpoena or modify the subpoena to extend the date of the response. You're not ignoring it. You're basically saying, I just got it. It's just not possible to produce these documents in 24 hours. And unless they have a trial set or they have something so critical that they need the documents immediately, 9 out of 10 times they're going to say, okay, you know what? When can you provide them to me? And we'll make an accommodation. But clearly, you got to receive the subpoena in order to comply with it. So that's not going to be a problem, and it will be unreasonable not to give you enough time to do so. Ignoring the subpoena is not a good idea. Just do not ignore it, because what happens if you say you ignore it and you were properly served and there's proof of service, that's one, or you decide I don't want to comply with it. I just don't feel this documents are relevant. I'm not going to do it. You choose not to provide the documents. That is just not a good idea. If you choose to ignore the subpoena after you've been properly served, or decide you don't want to produce documents, which is basically the same thing, then the attorney has the ability to go to the court and file what is called a motion to compel subpoena, the subpoena. And the attorney will go to the court as the judge, we served the subpoena to this witness. It was properly served. We actually had the date. We had in that particular case, you have a co-reporter present at the date that you're supposed to show up at the deposition. You don't show up. You don't produce documents. They file what's called a certificate of non-appearance. It's filed with the court. The judge will say, okay, what happened here? We were ready. They didn't show up. We try to call them. They're just not complying. They don't want to comply. The judge will enter an order compelling you, giving you some time, compelling you to produce the documents or comply with the terms of the subpoena. Okay? It'll give you some time to do that. It'll give you one shot. Okay? You get kind of a free pass in this case. You say you still do not want to comply. You don't care. Again, it's not a good idea. I'm giving kind of an extreme example here because most people won't comply after the first order. Say you do not comply a second time. Go back to the judge. Judge, they still do not comply. In this particular case, you have an order from the court for you to comply. And you choose not to. at that particular case, you might be in contempt of court. So first you were a material witness that had nothing to do with the litigation. Now you're kind of in the case because now you're not complying with a subpoena, then you're not complying with a court order. Now the judge will have to make a determination and how to proceed. All judges do not like orders disobeyed. So the judge in this case will enter what is called an order to show cause, why you should not be held in contempt, and give you additional time to cure the contempt. Maybe give you 10 days. Say, okay, at that particular point, you're ready in checkmate. You have to get this done. You still do not want to do it. At that particular point, the judge has the ability and can file a contempt order and actually add a writ of attachment and get you arrested and have you hauled into court for you to explain why you did not comply with a subpoena. So I'm giving you an extreme example. So the point is, treat the subpoena as a court document, as a court order for you to comply. The sooner you do it, the better. And just avoids problem because you're not even part of the case. You're not part of the litigation. You're a witness. So the same applies with documents that are when you receive a subpoena to testify. This one is a little tricky because 9 out of 10 times you're not called in advance. The attorney, the attorney should call you in advance. Say, listen, I want you to testify in this case. We're trying to schedule your deposition. We're going to issue a subpoena. Are you available the following days to testify? And work around your schedule because you have other obligations. And again, you're not even part of this case. You have no idea this case exists. But you apparently have information that is material to the case. And they want to ask you some questions on their own. Fair. Okay? So let's say you get a subpoena and then that's to testify on a Wednesday at 10 a.m. in the middle of your workday. And you say, I cannot just take time off for this. It's nothing to do with me. What happened? Or you have a doctor's appointment, you have other obligations. Remember, you're not even part of this case. You just received this out of the blue. So in a case like that, again, I do recommend calling an attorney to at least advise you about what the subpoena is, just the same I talked about the ducis tecum, the same thing about testifying in a type of deposition. It is under oath. Call an attorney, have explained to you your rights when you're being deposed. You might want to have the attorney present if you want to. Now that's your preference. But in a case like that you cannot make that particular date for the subpoena, in that case, just call the attorney and say, or send an email, say, listen, I received a subpoena. I'd like to, that particular day, I have other obligations, and provide an alternative date for you to be able to have your deposition taken. You can also ask, how much time do you anticipate me being in this deposition? It could be an hour, it could be 2 hours. So just find that out. It'll tell you, say, listen, I need the following information. I need you for 2 hours. It can be done via Zoom. And you can coordinate. And the attorney will work with you because you're not part of the case. You're not simply your witness to get information from you under oath, on the record. But nobody's going to force you, nobody should force you to testify in a particular date and time, especially when it's inconvenient for you, or you cannot do it for whatever reason. Say you're out of town, you're traveling, which is not possible. So, what we do is accommodate. So, okay, when can you do it? We'll go ahead and reissue the subpoena, or basically change the date, and do a notice of that taking deposition. We agreed that you're going to appear on this date. We'll coordinate. In either case, do not ignore it. Do not panic. The same thing applies if the deposition subpoena is received. You received the subpoena, and the date of the deposition actually passed already. Okay, so you're not in any trouble because you have not received the subpoena in the first place. That happens all the time. As we're trying to serve someone, the day passes, no problem. We get it rescheduled. You've been served. You're under subpoena. We'll get it rescheduled. Let us know the time. We'll figure it out. Okay, so either way, do not panic. and then do not, don't get stressed out for that. Now, if you're concerned, let's talk about you testifying in a deposition. You're not part of the case, but you could be part of the case. So that's a little bit tricky there. So maybe there might be some type of breach of contract issue that maybe you were not initially included into the lawsuit, but you're concerned that by testifying, you could easily be brought in as a defendant. There will be claims against you. In this particular case, you still got to comply with the subpoena, but my advice to you is to get the advice from an attorney before you show up to that subpoena. Just get to that deposition. Talk to an attorney. It is attorney-client communication, and the attorney will call that attorney and say, okay, what are the topics that you want to talk about? What specifically you need from this witness that is important to your case? And that conversation takes place, and then they can agree to narrow the scope of the discovery, the scope of the deposition to certain topics, or again, if it's something that could be prejudicial to you, there could be a protective order being in place. There are a lot of different tools that we have available as litigation attorneys that we can utilize to protect you. But in order for us to do that, use them, we need to understand the nature of what you're going to be asked. And that conversation needs to be had. So my advice to you, if you receive a subpoena, number one, do not panic. Number two, do not ignore it. Do the best you can comply with the subpoena, but also get the advice of counsel to be able for you to be better equipped in how to properly comply with that request. And so that's very important. And again, don't panic. There's also another example that I want to share with you about subpoenas is to third parties. Say your accountant, say you have a CPA, and all of a sudden your CPA receives a subpoena for your records. So that is very important. For your financial records, your tax records, all the backup material that you provided, all that information. Say, and that happens sometimes in business litigation, we sometimes, serve the accountants. In Florida, there's something called accountant-client privilege. So it is important that if your accountant receives a subpoena for your financial documents, you have to contact an attorney immediately. There are some situations in which the information from a CPA can be obtained for litigation. But there are also situations that communication, that information is confidential and privileged. So, your CPA should notify you immediately when a subpoena for records have been requested of him or her. And then you need to get an attorney, a business attorney that will help you. I'm not talking here about a business context, but by the way, this also applies to personal. There's information between you and your CPA communication. It is privileged. It is confidential, just the way the communication between the attorney and the client. There's some protections that we have. So in this particular case, what you do is just call your attorney and I said, get a copy of the subpoena, send it to your attorney. Usually you have a little bit of time, and then the attorney will determine, again, we'll go through the same analysis and determine whether or not this subpoena is valid, whether the subpoena information sought is relevant, whether the information sought is privileged, and whether or not the information he or she needs to file a motion protective order on the basis of accountant-client privilege. The same thing applies to medical records. You have a doctor-client privilege, and medical records are subpoenaed all the time, especially in the event and the cases of personal injury or accidents. But you have to have consult an attorney to determine how to handle that subpoena, whether it's going to be challenged comply with. And if it's not properly served, whether it's going to be with something called quash the subpoena or eliminate the service of the subpoena as well. So there's a lot of tools that are available. My advice to you is don't go out alone. Okay, you received it, don't panic. You read it. It's not a pleasant experience to receive a court document from any kind. So I get it, but don't immediately start acting upon it without consulting with an attorney. It might be something very minor, but it could be something a little more, major. So you don't want to go ahead and act without actually having the proper legal advice. So I think that's good for the topic of subpoenas today. Again, receive a subpoena, call an attorney to advise you what to do with it. That's the takeaway for today. If you want to reach me, if you have any questions about this topic or any topics that I've covered before, or anything regarding business law, anything regarding legal issues about small business, please send me an email at rich@richsierra.com. If you want to learn more about our legal services, our website is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. If you want to watch this is a podcast. If you want to watch the video of the podcast, we actually have the video as well. We're on youtube.com/@RichardSierra. We're on X at @Rich_Sierra. We're on Instagram at FSB Legal. If you want to give us a call, our number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstore. I'd like you to follow the show. If you like the show, please follow us and give us a 5-star review. I appreciate that. So that way we can, the algorithms, we can recommend this to other business owners, and feel free to share this information to whomever you want to. Also on the YouTube channel, I'd like you to subscribe as well. Right now we have over 7,000 subscribers, so I'm very excited about that. I'd love to hear from you. Again, until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.